22-769, State of Nevada versus Lashawn Smith. May the record reflect that Ms. Smith is present at liberty. Ms. Jackson is here on her behalf. And may the record reflect Mr. Smith is also present at liberty. Mr. Draskovich is here on his behalf. Ms. Luzaich is here on behalf of the state. Mr. Draskovich, you filed a joinder. I have not seen it.
I have a copy of the court with me.
Well, no, I'm looking it up and honestly. You filed it in your client's case?
Correct.
That's the thing, I didn't pull up your client's case for today, and I apologize.
That says count 11.
Okay. Ms. Luzaich, have you seen the joinder?
Yes.
Okay. I'm going to grant Mr. Draskovich's joinder in the motion. I have read the motion. This is all for the defense motion. I have read the motion. I have read the state's opposition as well as I read the reply that was filed by Ms. Jackson. The state has indicated that they are no longer proceeding on count 11. So the only issue that needs to be resolved is Ms. Jackson's argument in regards to, well, let's back up. You're no longer proceeding on count 11 in regards to both defendants, correct? Okay, so count 11 will be dismissed in regards to both defendants. Ms. Luzaich, I would need an amended to reflect count 11 in regards to Mr. Smith, that count 11 was dismissed, because Ms. Jackson's second argument is dismissing the indictment in its entirety in regards to Mrs. Smith based upon the delay in bringing the charges. I have read those arguments, as well as there was a little bit of a sufficiency of the evidence argument that was made in the reply that I did read as well. So Ms. Luzaich, I'm going to give you an opportunity to respond to that, because it was in the reply.
Yeah, I snuck in a disguised petition for habeas corpus in the reply. The court has already heard a writ as it pertains to Bobby Smith, and the court found sufficient evidence to proceed to trial on all counts, and he is named in that count. And specifically, the state doesn't have to negate every other possibility. There just needs to be some evidence that it was a sexual assault. Obviously, a whole different burden at trial. You know, we talk about reasonable consent and all those things, and grooming come trial, but for purposes of this, Attorney Lacey indicated that she didn't want to do this. In fact, she had a conversation with Lashawn Smith earlier the day that that count occurred, and told her that it made her feel uncomfortable what he was doing, her parents would never approve, and Lashawn Smith told Attorney Lacey that her daughter, Erin Spivey, doesn't like it either and feels the same way. And they talked, and Lashawn Smith actually told Attorney Lacey that she would talk to the goddad and it wouldn't happen again. So for purposes of probable cause, there is certainly sufficient evidence to send it to a jury.
Okay. Ms. Jackson, anything else you want to add?
The court has read everything, and I'm not going to just repeat what I have put in writing. But I think that as to my client, the case needs to be dismissed in its entirety.
Okay. Mr. Draskovich, I did grant your joinder. Is there anything you wanted to add?
We've laid out the prior arguments, obvious evidence, he should not proceed to trial because.
Understood. Yes. And I did hear a writ in regards to Mr. Smith, and in hearing that writ, I did have an opportunity to read the entirety, because if you recall, you filed it, you guys argued it, I reread the entirety of the grand jury transcript before I ruled on the writ. In that case, Ms. Jackson, you hadn't come on the case yet, so I did have that opportunity. And while Ms. Jackson, I understand the arguments that you're making, it's a sufficiency of the arguments, sufficiency of the evidence argument that needs to be made in a writ of habeas corpus. And so at this stage, this court has found that there was slight or marginal evidence for this case to proceed to trial, so I am going to deny the motion on those grounds, but count 11 will be dismissed in regards to both defendants. And Ms. Luzaich, I need an amended indictment.
Yeah, I just didn't want to do it.
No, I get it, yeah, you'll just need to file that and dismiss and count 11 in regards to both.
May I just briefly supplement the record in the unlikely event that there is a conviction in this case?
Okay.
May the record reflect that I have oftentimes argued under NRS 174.075 that statute is there for a reason that it does not necessarily, conflict with the statute regarding petition for writ of habeas corpus. It is our position, we read the statute to say, court, you can recognize at any time, whether it be for statute of limitations, or other reasons that the court lacks jurisdiction, that the court can certainly notice that judicially, especially when counsel brings it to their attention, that you lack jurisdiction over a particular count, and that I believe that it is cognizable under NRS 174.075. But because I am, as we speak, in a CLE on ethics, and in total candor with the court, I make this argument for a long, long, long time, and I have not won it yet. But I still believe that, just like, you know, the jury instructions that were argued for 25 years, and now we finally get them, that I believe that I am correct.
Totally understand, I appreciate that, Ms. Jackson. So as soon as you prepare the amended, your dates will stay.
Thank you,
Okay,
Your Honor.
thank you, guys. All right, so the matter versus Lashawn Smith. May the record reflect that Ms. Smith is present at liberty. Ms. Jackson is here on her behalf. Ms. Luzaich is here on behalf of the state. Go ahead, Ms. Jackson.
Your Honor, when I filed the initial motion, I filed a petition and an affidavit executed by my client indicating that she is out of funds, I am privately retained, and that on this matter, private investigator Ken Hardy, I think was appointed pursuant to WIS to work with Mr. Draskovich. I have conferred with Mr. Hardy and Attorney Draskovich, and the only thing we would ask is that this court would authorize additional hours for him to do any work that we may need. The record will further reflect that Mr. and Mrs. Smith, along with their attorneys, perceive no conflict, and if there is any, we would bring it to the court's attention. If the court requires, they will both execute written waivers, although I cannot imagine that there will be, but in an abundance of caution, we can do that. We can ask the court to sign an order granting us an investigator, a private investigator, and or any other experts that we may need, subject to approval by the court and Office of Appointed Counsel.
Okay, you can submit those orders, I'll sign it, but I am gonna want a conflict waiver if they're using the same investigator.
Very well,
Okay.
Your Honor. Thank you.